Welcome to I Couldn't Help But Wonder, Divorce Decoded, the podcast where we untangle the legal, emotional, and financial threads of modern family law, one story at a time. I'm Lorraine Silverman, and today we're talking about what happens after the ink dries and life changes. Because sometimes what worked at the time of your divorce does not work anymore. You signed, you settled, you started your next chapter. But I couldn't help but wonder, what happens when your ex gets a new job, when the kids start a new school, or when your carefully crafted parenting plan no longer fits the life you're actually living? Because in family law, one of the most powerful and misunderstood tools is the ability to modify what's already been ordered. The story, the physician and the pilot. Sophia was a cardiologist in Albany. Her ex-husband, Mark, was a commercial airline pilot. Their original parenting plan gave him weekends and some holidays based on his flight schedule. But 2 years later, Mark changed careers. His new job was local, predictable. He now wants shared physical custody. Sophia, whose practice had expanded and who had recently added hospital administrative duties, wasn't opposed. But she wasn't sure what the law allowed. Was she obligated to agree? Was it even modifiable? And what standard would the court use to decide? The legal breakdown. How modifications work in New York. In New York, court orders regarding custody, parenting time, and child support can be modified, but only under certain conditions. Here's what the court looks for. Custody or parenting time. A subsequent, substantial, and unanticipated change in circumstances, such as a new job, relocation, changes in the child's needs. For custody cases, this is a two-part test. First, the court reviews the matter to determine if there has been a subsequent, substantial, and unanticipated change in circumstances. If the court finds that there has been, then the court looks at whether that change to the order requested by the petitioning parent would be in the children's best interest by reviewing factors such as relative fitness of the parents, stability, past performance, home environment, the ability to guide and nurture the children, each parent's ability to foster and facilitate a relationship with the other parent, untreated mental health of the parents, untreated alcohol or substance abuse issue of the parents, and domestic violence, which is the only factor the court must consider, and the court is required to give credible allegations weighty consideration. It is important to note, even if the court finds that there has been a change in circumstances, and even if the court conducts a best interest analysis, the court could ultimately determine that it would not be in the children's best interest to make the change requested by the petitioning parent. The point here is that it is not about what is best for the parent, but what is best for the child. Now, child support. A subsequent and substantial and unanticipated change in circumstances, 15% change in either parent's income, or a passage of 3 years since the last order can trigger a review, though the court still has discretion. An example of a subsequent substantial and unanticipated change in circumstances might be a mass layoff by a company. A party requesting a modification must file a petition in family court or a motion in Supreme Court, if that's where the order was issued. And yes, if you have a high income, a private agreement, or a more complex custody structure, the modification must reflect the sophistication of the original deal. Strategy matters. The takeaway? Agreements aren't always forever. They're based on facts that were true at the time. If those facts change and your parenting plan, support structure, or custody agreement no longer reflects your child's best interests, you may have the right to ask the court to review it. Just make sure you're guided by legal strategy, not emotion, because a well-crafted modification can bring stability, not chaos. Thanks for joining me on I Couldn't Help But Wonder, Divorce Decoded. Next week, we're talking about one of the most critical and misunderstood tools in family court, orders of protection, who they're for, how they're filed, and what they don't do. Until then, if your existing agreement no longer fits your family's reality, visit thecdslawfirm.com for thoughtful, strategic legal guidance tailored to your life.